Morning, guys. Back for the fourth lecture on the Judicial Branch. I haven't had very many views, even though I'm showing this to three classes on YouTube. So, listen, this stuff is probably things you don't know very much about. So, if you want to do well on that last test, it might be a good idea to watch the videos. But anyhow, I'm going to keep going for those that are watching. Thank you for watching. All right. So 9 steps of a trial or an arrest, just kind of that process of how our system works. Okay. Hopefully none of you ever have to go through this as an individual, but if you do, this information may be helpful. Okay. So as far as an arrest goes, without a warrant, police must have sufficient facts to convince a reasonable man that a crime has been committed in order to make an arrest. Okay, so you can get a warrant if you have certain things, or a lot of times when we talk about like being pulled over by the police and what goes on there. Okay, so there must be probable cause. So like to search your vehicle. Okay, so if they come up to your window and they pull you over and they smell alcohol on you or in the vehicle, that's probable cause to search the vehicle. Okay. If they do not have probable cause, they can ask for a warrant to get from a judge presenting probable cause, so that they can check. Okay. This is a detached neutral magistrate. That's a judge. Okay. They are not part of the situation. They're not the cop or the individual. The cop explains to them what they know, and they say, yes, I'll give you a warrant to search this person's home, their computer, their phone, their vehicle, that sort of thing. Okay. Now, in a situation where it's just you and the police, if the cops see or witness a crime. So in that case, like if you get pulled over and you've got a bottle of beer sitting in the center console and it's open, well, a crime is being committed. It's called open container while you're driving. Okay, that's a crime. If they see, a pot bong sitting in the front seat next to you, okay, a crime is being committed. Okay. Reasonable suspicion is also another factor. Okay. Now, if you look really nervous, okay, while the police are pulling you over, well, guys, most people are nervous. I get nervous even when I really haven't done anything wrong, except maybe done some speeding or something like that. Okay, so moving on here. Searches without a warrant. Okay, so they see the beer sitting in your car. A crime is being committed. Okay, they can make an arrest and search the area around you. Okay, to make sure there's no other laws being broken, like there's a gun in the car or there's drugs in the car, that sort of thing. Okay, now this is something that's been talked about a lot, actually recently, and that is stop and frisk. Okay, one of the ways that police try, or mayors and police forces try and clean up a high crime area, is by a strong police presence and using stop and frisk. Now, if a police officer sees, some people hanging out on a street corner, looks like they're up to no good, maybe they're dealing drugs, can the cop go up and just search them? The police officer has to feel there's a legitimate threat to those around him. So legally, guys, they're not really allowed to do that. Okay. Just because you look suspicious. Okay. Now, if they see like a bulge in your waistband, like maybe there's a gun there. Okay. They could do that, or they could ask you, because now with, conceal and carry laws and so forth, a lot of people can be packing legally. Okay. So they may ask consent to search. Now, if you get pulled over and you haven't done anything wrong besides, say, maybe speeding, you may have a cop ask to search your car. You do not have to consent to that, okay? Now, can he go ask for a canine to come and, sniff your car? Yes, okay, if he has some suspicions. Otherwise, you don't have to, okay? Plain view is what I was talking about. They can see there's a crime. You open your window and pot smoke billows out of the car, that sort of thing. If the cop is chasing someone, they start running in their car or on foot. Suspect goes into a building. The police can follow you into that building and seize anything found while following them. So mostly that would be into your house. Okay, if you fled to your home, went in there, and you're suspected of a crime, and they find a meth lab in there, they can seize that. Okay. Can search your vehicle with probable cause, think you're going to flee. Emergency situations, they can go into a house if they feel like somebody in that house is in danger, smelling smoke, hearing a scream. They can go in. If they really feel somebody's life is being threatened, they don't need a warrant for that. Okay. Now, you can throw out all these things at the border. As you guys know, if you come through the U.S.-Mexican border, Canadian border, they can search your vehicle to look for contraband. And then at the airport, guys, holy cow, they do random searches of the body. They do, obviously screening your luggage, opening your luggage, everything else, testing it for bomb residue, all kinds of things, okay? So your rights kind of don't apply here, okay? If you are going to be arrested, of course, Miranda warnings must be applied, and no forced or coerced confessions are allowed, okay? Now, can they question you for hours? Yes, okay? And sometimes they wear people down or get them to, tell a lie, and then they have a hard time, continuing that lie as time goes on, okay? But as far as, torture, these sorts of things, obviously they're not allowed to do that. Okay, so let's say you're charged with a crime, okay, or you're arrested, okay? A lot of times we have grand juries in panel. These are done in federal cases. Grand juries are 23 members. So you get jury duty, and you'll sit for a few weeks on these grand juries, and they will bring cases in front of you. And they'll just set the evidence in front of you and tell you what they think happened. And then the grand jury, a majority of them must come back and say, we think a crime has been committed, okay? Based on the evidence, the suspect could have committed a crime. They will return an indictment, okay? You see this in federal cases. An indictment is a charge, okay? Now, if you get pulled over, I don't know, let me come up with an example. Let's say you and your friend were sitting in your car and you were smoking weed and the cops rolled up on you, okay? So you're busted, all right? So they're going to take you down to jail, and you're going to be arraigned, okay? They bring you before a judge to be charged. Okay, that arraignment's usually going to take place within 72 hours, okay? So you'll have time to get an attorney, make your phone call, and meet with them and discuss your strategy, okay? The accused may plead guilty or not guilty. Now, what happens with a lot of cases, especially for like first-time offenders, is that lawyer will go to the district attorney, the prosecutor, and say, okay, look, this person's never been in trouble before with the law. It's a minor crime. Can we do a plea agreement, okay, or a plea bargain? And what that would mean is, okay, well, we're going to have you do 12 months of probation and 100 hours of community service. Since it's your first offense, we like to give second chances in this country. If you complete those two things within a year, we will expunge your record. They will, basically hide that offense that you had. Okay. Now, if you get in trouble with the law again, that record that's been expunged will be brought back out into the open. Now you have 2 times you've been in trouble with the law. Does that make sense? Yes. Okay. So here you'll get sometimes guilty, not guilty. Now, if you plead guilty, there's not going to be a trial. Okay. You'll have a sentencing hearing. Okay. Or they'll just say, look, if you plead guilty, you're going to do 30 days in jail, and then we're going to let you out. Okay. And it's over. Okay. Not guilty, this is where you'll get a trial. Now, the courts don't like this because they tie up the courts with a lot of cases, and, they get behind, and, people sit in jail. Okay. Preliminary hearing. Okay. So, you're being charged. You're pleading not guilty. Okay. Judge is going to determine if there's significant evidence to have you bound over for trial. Okay, and this is where you're either going to have jail or bail. Okay, so if they say, well, this person is not a flight risk, this was not a major crime. Now, if you have murder type situations, a lot of times they don't want you out of jail because you've already killed somebody, likely. And what's the chances of you doing that again while you're waiting your trial? We're not going to let you out. Okay, no bail. Okay. And then they're going to try and have a trial within 120 days. Okay, that's that speedy trial. Okay, now the bail or the fine cannot be excessive. Okay, so the bail should fit the crime. So if it's, let's say you rob a convenience store without a gun, okay, that's going to be seen as less of a crime than with a gun, armed robbery, okay? So the bail for an armed robbery may be, $50,000. Okay. So how do you get out of jail while you wait for your trial? Well, you're going to have to come up with 10% of that. Okay. So $5,000. Then you get a bail bondsman and you use your parents' house or your house for collateral. So if you don't show up for the trial, then the bail bondsman gets your house. Okay. If you show up for trial, the bail bondsman keeps a cut of the bail of the $5,000 that you put up. Okay, as payment for helping you get out of jail before trial. Okay, bail can be denied in some situations, as I said. Now, bail is something that is really up for debate, and New York just recently stopped using bail. So basically, you get arrested for assaulting somebody on the subway, they take you down and book you, and then they kick you loose and give you a trial date. Okay, so if you're a violent offender, you're able to just keep doing that over and over again, and they keep releasing you from jail. It's kind of crazy. But on the other side of that, bail is really, I think, unfair to poor people, where the wealthy have this money to get out of jail. Poor people often don't, and so they have to use a bondsman, or they get caught in the system. And so I think it's something to look at. I don't know if there's a fix for it, but I think doing away with it is really kind of scary for society, to let just book people and cut them loose, especially if they're violent. So, all right. So now you're waiting for your trial. Okay. Usually after 120 days, the defendant goes free. Okay. Speedy trial. Trial by jury. Okay. Now, in criminal cases, you have the right to a jury of 12, a jury of your peers. Okay. So these will be people in the community that will be called for jury duty. Your community. Okay. And this is public. Okay. Normally, and that's Sixth Amendment. Okay. The Fifth Amendment, okay, provides for no self-incrimination. You can't be forced to testify against yourself or your spouse. The assistance of a lawyer, counsel. You have the right to confront the witness, which a lot of times is the police. Okay. And once that trial, once you're pleaded guilty or not guilty, you cannot be tried for that crime again. Okay. Trial goes on. Okay. If you're with a verdict, you not guilty, you go free. Okay, now that's got to be 12-0, guys. Okay, and to 12-0 for not guilty, 12-0 for guilty. There were 2 states that the Supreme Court just ruled on this that said you needed a majority to be found guilty, not 12-0. And the Supreme Court just overturned those 2 states and said, no, you need to be unanimous, 12-0, okay, which I think is right. Some of you guys have seen the movie. Some of you guys acted in the play, 12 Angry Jurors, okay. Time the movie was called 12 Angry Men. But anyhow, it's an interesting process of how that works, okay. In a case like this, guys, the prosecution always goes first and the defense always goes last during a trial, okay? You always get the last word, the defendant, okay? So they can claim something and you have the right to defend yourself from that claim, always, okay? And so in the closing arguments, the defense attorneys always get to go last, okay? They get the last word. Okay, so if you're found guilty, sentencing is done by the judge, except in cases of murder or rape. It does depend on the state you're in, of how this exactly works, okay? But otherwise, the jury may be doing the sentencing, okay? Appeals. Now, of course, you may not like the outcome of your case. You may be found guilty, okay? They can appeal. And then, as I talked about earlier, the 3 judge panels that hear these appeal cases. And again, they're looking at the trier of law here, not the trier of facts. The facts have already been determined. So they may affirm or uphold the decision by the lower court. They may reverse it and nullify it, or they may remand it back to the trial to be redone. So you may get a new trial if, say, the judge didn't do something right, or your attorney didn't represent you well, or that sort of thing, okay? All right, as far as jury duty goes, if you ever get called, I've never been on a jury. I've been called for jury duty, but usually you'll get a summons, and it'll say, you need to call this phone number between this hour and this hour on this day, and we'll let you know if we need you. I've done that, and they said, sorry, we don't need you. But my wife, and I know a lot of people that have been called, so they're going to call in 24 people, okay, for jury duty, all right, if there's going to be a trial, all right. And all the while, guys, while you're getting ready for this jury duty, the 2 sides behind the scenes, you know, the prosecutor and the defense could be working out a plea agreement, a plea bargain. You may go through all these steps, and they say, go on home. They did a deal, okay. So, with this, guys, 24 called, I don't know how to pronounce this, Voidire, something like that, sorry. But this is the process, okay? So, under the law, the judge is permitted only to excuse you from jury duty if you're required elsewhere for public welfare, health and safety, you're so physically or mentally infirm that you're not up to the task, you've served in a jury in the last year, jury service would cause you extraordinary compelling hardship. It's hard to get off a jury. I'd say if you're a cop, you're probably not going to get on a jury. They don't let them on very often. If you're a firefighter, you might be able to get off. If you're a surgeon, a doctor, public health, these sorts of things. But if you're just a regular person that works 8 to 5, a teacher, something like that, they're going to make you serve, okay? Now, because there's 24, each side gets to interview these 24, and they get to dismiss 6. Each side can dismiss 6, okay? So you're trying to build a jury. There's a whole science behind this. Depending on what your client's charged with, what race, what age your client is, you're looking for a jury that could be sympathetic to the defendant, or if you're the prosecutor, you're looking for people that you think, will think this person's guilty, okay? So they can, they can excuse 6 for whatever reason. It doesn't matter, okay? For no reason whatsoever, okay? Sometimes in a big case, they'll have alternate jurors, like in a case that's going to last a month, because sometimes the jurors that are chosen mess up. Sometimes they're supposed to be sequestered. That means they're not allowed to watch the news, talk about the case, these sorts of things. And if they get found out, you have alternates that are going through the same process. They're hearing all the evidence and everything, and they may dismiss a juror if need be. Okay, so big cases, you'll have some alternates. Okay. The trial itself, I kind of talked about this. Opening statements, prosecution always goes first. Presentation of evidence, prosecution goes first. Closing arguments, so obviously defense goes last. Okay. After the closing arguments, the jury will get instructions from the judge. They'll elect a foreman, or a four-person, kind of the leader of the 12, and they will deliberate. Okay. They'll discuss the evidence, instructions, and then a verdict is reached. Okay. Now, if you can't get to a 12-0 one way or the other, it's basically called a hung jury. The judge can say, no, you guys go back in there and figure this out. And still it's a hung jury. So the jury, in a hung jury, the case is over. Okay. Now, you are not found guilty. You are not found innocent. Okay. Can they try you again? Yes. Okay. If more evidence comes forward. Okay. Now, for this reason, guys, prosecutors do not like to bring cases to court if they don't think they can win the case. They can win the trial. Okay. Prosecutors, they keep statistics on how many convictions they get and how many they lose. And these prosecutors, they're politicians. They have to run for these offices and so forth. So they don't like to bring these cases unless they can get a guilty of the defendant. Okay. So once the verdict is reached, it's read in open court. The jury is discharged. Okay. And that kind of sums up the situation there. Okay. Guys, usually I get a ton of questions on this stuff during the lecture, but it's stuff you can look up. And so I'll have some questions on the test about this and the rest of the Judicial Branch, which I will post next week, and that'll be it for this class. All right. Hope you watch these. Hope you're well. Hope your families are well. I'm going to do a little message for all my students here next week, just kind of a goodbye. Those are hard to say, but just want to share some things with you and chat. So you guys take care of yourselves, and we'll see you next week, okay? Chat at me if you got any questions. Bye.